Hello everyone, my name is Danielle Smith, and today I will be talking about workplace discrimination. There are several types of workplace discrimination, including race, color, religion, gender, national origin, age, and disability. Within our readings, Miller describes the importance of the civil rights movement of 1964. Out of the civil rights movement grew a body of law protecting employees against discrimination in the workplace. Legislation, judicial decisions, and administrative agencies' actions restrict employees from discriminating against workers on the basis of race, color, religion, national origin, gender, age, or disability. A class of persons defined by one or more of these criteria is known as protected class. Miller also describes that the most important statute covering employment discrimination is Title VII of the Civil Rights Act of 1964. This act prohibits all discrimination against employee applicants as well as union members based on their race, color, national origin, religion, or gender at any stage of employment. A special section of the act prohibits discrimination in most federal government agencies. Now let's take a look at several cases that have to do with workplace discrimination. We'll start with race. This is a lawsuit that resulted in Robert Sanders being paid $165 by Big Five Sporting Goods. On September 18, 2018, the EEOC released a statement of the suit against them versus Big Five Sporting Goods Corporation. In this case, the victim, Robert Sanders, was a victim of racial harassment, and he also received a numerous amount of death threats. He was called Spook. He was also called King Kong, and he was told that his face reminds them of a janitor. In addition to that, an assistant manager allegedly said that we will hang you and we will seriously lynch you if you call in again this week. Another assistant manager asked Robert Sanders if he was ready to commit suicide and that he could offer assistance. The victim was forced to go on several leaves of absences due to stress of all the racial harassment. Due to all the leaves, Big Five ended up terminating Sanders. Under Title VII of the Civil Rights Act of 1964, racial harassment and retaliation is prohibited, and Big Five was in violation of this law. Here's another case that deals with workplace discrimination. For this, it has to do with religion. This is a case, EEOC versus United Health Programs of America. They violated the federal law by making employees engage in religious practices at work. The EEOC claims that the CCG employees, which is a parent company of the United Health Programs of America Incorporated, were forcing their employees to engage in religious activities, including prayer, religious workshops, and spiritual cleansing rituals. Title VII of the Civil Rights Act of 1964 forbids employers from forcing employees to engage in religious practices at work. It also bars employers from firing or taking other adverse action against those who oppose such practices. Here is another case, and this has to do with sex. This is Onkel versus Sundowner Offshore Services Incorporated. The victim, which is Joseph, a male employee, filed a complaint against his employer, Offshore Services Incorporated. Joseph stated that he was sexually harassed within the workplace. Now, the biggest question is, does the Civil Rights Act law prohibit sexual harassment in the same way that it does with discrimination based on someone's sex? The court ruled yes. The court held that while Title VII does not prohibit all verbal or physical harassment in the workplace, it does bar all forms of discrimination because of sex. The next case that we'll be discussing is Land Systems versus Klein. General Dynamics Land System revised its contract to provide full health care benefits only to retirers who are over the age of 50 years old. Denise Klein was 48, just a few years shy of 50, and was excluded these benefits due to their age. Klein, among other employees who ranged from the age of 40 to 49, decided to file suit against General Dynamics under the Age Discrimination in Employment Act of 1967. Court rules that General Dynamics was guilty of plain age discrimination, since the ADEA protects all persons over 40 from age discrimination by their employers. The EEOC, better known as the Equal Employment Opportunity Commission, is compliant with the Title VII under the Civil Rights Act. Victims must file a claim with the EEOC before bringing suit against an employer who has potentially violated Title VII. The Equal Employment Opportunity Commission may file suit with the employer. They also investigate primarily priority cases. They actually don't investigate all cases that a claim is made on. If they decide not to go forth with a claim, the victim has that decision to bring their own personal lawsuit against their employer. If you feel like you have been a victim of workplace discrimination, follow the link below. This is how to file a charge of employment discrimination with the EEOC. Here's a list of all my references. Thank you very much for listening to my presentation.